Good evening, everyone. I am CA Paramveer Kaur, moderator of this webinar. We are delighted to welcome you all in the webinar being organized by CCLEA and NPO Committee of ICAI. It is my pleasure to be a moderator in Know Your Law Series 49, webinar on IPR, Legality and Utility for Chartered Accountants, being organized by Committee on Commercial Law, Economic Advisories, and NPO Cooperative of ICAI. In a short while, we'll start this webinar. I would like to apprise you about CCLEA and NPO committee. This committee is focused to encourage chartered accountants to shape strategy and policy that unlocks economic, financial, and social value while combining analytical foresight with commercial acumen. One of the core areas of this committee is to serve the multifunctional task of analysis, knowledge dissemination, inputs to regulators on policy formulation, to develop and publish technical guidance, background materials, etc., and to create awareness for professional opportunities for chartered accountants in commercial laws, economic advisory, and NPO cooperatives. Our eminent speaker, Advocate Sushil Tatir, will talk on IPR, legality and utility for chartered accountants in this webinar, and we hope that the same shall be useful to the members. Kindly put up your queries during the session, which shall be answered by our speaker. Now, I would like to introduce our speaker for the session, Advocate Sushil Tatir. His academic qualifications include Bachelor in Commerce, Bachelor in Law, Masters in Commerce, Diploma in Computer Applications. About his work experience, he regularly appears before high courts, district courts, NCLT, IPAB, trademark registry, etc. Has been working as trademark attorney for more than 10 years, handles cases relating to banking laws regarding default recovery from banks as well as borrowers, has been legal advisor to initial public offers, has been regularly advising on insolvency and bankruptcy related issues, handling corporate litigations, and advising on commercial arbitration and related issues. He has trained legal officers of Bank of Baroda. He has trained various entrepreneurs at various forums, has been delivering lectures at various professional forums like ICAI and ICSI, training to insolvency professionals for preparation of limited insolvency examinations. We welcome you here, sir. I would now like to hand over the session to our speaker.
Thank you very much. Let me share the screen. I hope my slides are visible.
Yes, sir.
So, good evening, everyone. Welcome to this webinar on intellectual property rights, legality, and opportunities for chartered accountants in India. This is Advocate Sushil Tate and practicing trademark attorney, and I am delighted to share with you some insights and tips on how you can leverage your knowledge and skills in the field of IPR and explore new avenues of growth and development. Intellectual property rights or IPR are the legal rights that protects the creation of human mind, such as invention, designs, artistic works, etc. IPR can be a valuable asset for any business as it can help to differentiate its products and services from the other competitors, which enhances its brand value and generate revenue. As a chartered accountant, you have a vital role to play in the IPR ecosystem, as you can help to protect, manage, and monetize the IP asset of your own firm as well as your clients. I hope you will find this webinar informative and useful. Please feel free to ask any question or share your feedback during the session. Thank you for joining us today, and let's crack this. So today's agenda will be, we will try to understand the basic of IPR laws and practices in India and the international scenario around it. The different types of IPR such as patents, trademarks, copyright, design, geographical indication, etc., and their registration process, benefits, and challenges. Then we will focus on the role and responsibilities of chartered accountants as IPR consultant, auditors, and valuers, and the emerging trends and opportunities in field of IPR, such as IPR financing, licensing, litigation, arbitration, etc., and the best practice and ethical standard for chartered accountants in dealing with IPR issues. So basically, India recognizes several types of IPRs. The most common ones includes trademark, copyright, patent, design, and geographical indication. Each type of IPR has its own set of legal provisions and procedures for registration and protection. So if we see at the IPR legality, basically trademarks, which are usually known as brands, which are used to differentiate the goods of two different competitors, or we can say that which identify a product and gives it identity. It is protected by the Trademark Act 1999. Previously, it was protected by the Trademark Trade and Merchandise Act 1958. But since our nation is developing, our laws are also developing. Similarly, copyright is for the exclusive right for original literary, dramatic, musical, or artistic works, as well as films, sound recording, and it is protected by the Copyright Act 1957. And when it turns to invention, exclusive right for inventor are inventions that are new, useful, and non-obvious are protected by the Patent Act 1970. Similarly, aesthetic feature of any shape, pattern, or ornament or textile applied to any article are protected by the Design Act 2000. Similarly, geographical indications are protected by the Geographical Indication of Goods Registration and Protection Act 1999. And other than these, we also have a few more IPs in forms of layout design of semiconductor integrated circuits, which is protected by the Semiconductor Integrated Circuits Layout Design Act 2000. Then we have rights in plant varieties for new distinct uniform and stable varieties of plants, which is protected by the Protection of Plant Varieties and Farmers Right Act 2001. You may have noticed that Lay's potato chips have a consistent taste across different packets, unlike the vegetables and fruits that we buy from the market, which may vary in flavor. Then how does Lay's achieve this uniformity in taste for its large-scale production? The secret is their exclusive variety of potatoes called FC5, which they have developed and cultivated for their potato chips. This gives them an edge over the other competitors in terms of taste and similarity and uniformity. Moreover, this breed is protected under the Indian IP law, which grants PepsiCo the honor of Lay's exclusive right to use, produce, and sell the FC5 potatoes. Why is value addition is so crucial? It's because adding value enhances your brand, gearing up for large growth opportunities and fostering a mindset of continuous improvement. Let me share a real life example with you. A friend of mine once told me that my client pays me such a small fee that I can barely cover my expenses. I feel stuck and I think I need to find new clients. Do you have any ideas? I asked him to tell me the whole story. He said he had already shared everything. So I asked him, does your client pay any higher fees to any other professionals? He admitted that yes, the client did pay some consultants in the lakhs, but paid him very little. That's when I told him, your client is paying you what you are worth. Even if you find new clients, they will likely pay you the same. You need to increase your value and everything else will fall into the place. Similarly, consider two doctors who graduated from the same college, lived in the same hostel room, studied together from the same professor. One is charging rupees 5,000 for an OPD consultation, whereas the other one is charging only rupees 100. Yet the first doctor has more appointments. This is because of the value he has added to his brand. So the key takeaway is this: focus on enhancing your value and success will follow. So being chartered accountant, you are considered to be all business problem solutions, and the IP is the most key factor for any business. So you have to also be on the edge so that you can provide value addition to your client. When you are working in intellectual property rights, you can guide your clients in registering their IP rights. So whenever a client comes to you for their business registration or starting a business, you usually suggest them GST registration or whatever any other necessary registration which is required to start the business. But from now on, don't forget to advise them about registering their trademarks, copyright, patents, or design as may be applicable to a client. Then you can also assist your clients in renewing their IP rights. So it is again a new stream for generating revenues. If a client wants to license or sell their brand, which is known as assignment, you can help them draft legal documents, calculate valuations, and figure out the stamp duty and assist them to complete the transaction. And next, there is a brand management service. Once the trademark is registered or copyright is registered or patent is granted, client need a protection chain because it is like a property. अगर हमारे पास घर है, मकान है, उसको हमने खरीद लिया है, बहुत अच्छे से बना भी लिया है, लेकिन if there is no चौकीदार, then there is a fear of theft. So in the same way, you will need to keep an eye on the journal published for the trademark, design, patents, and even work which is published for the copyrights, so that your client's IP can be protected from being used by others without their permission. You can charge an annual fee for this service, and if there is a dispute, you can guide your client on how to protect their IP in the IP forum or in court of law. And alternatively, if your client is buying a new business or IP, you can help them by doing a legal check known as due diligence to find out who really owns the IP and its valuations. Because sometimes what happens when new company or new startup is formed, they obtain IP rights in the personal capacity of promoter, partner, director, proprietor, in whatever name you say. And when anybody is investing in a company or in a firm or in a LLP, he is investing due to IP rights. But since IP rights is not available in the name of company, then what is the use of that investment? So you can due diligence, you can check it and due diligence it, and you can guide your client so that he can execute that transaction very fluently. So now we will discuss trademark. A trademark, I mean, I hope you will all be aware about the trademark, but you will be surprising to know that a trademark can be word, phrase, symbol, or design. Numeric, it is common, but color, sound, and shape can also be registered as a trademark. So whatever name or symbol distinguishes the goods or service of one seller from those of others, that is trademark. So we can say that trademark are distinctive signs that identify the source and quality of goods or services in the market. They can be words, logos, slogan, color, shape, sound, or any combination of elements that distinguishes one product or service from other. And trademarks are intangible assets that can create and enhance brand value, reputation, and goodwill of a business. They can also generate income through licensing, franchising, or selling, called as assignment. So these are the few types of trademarks. First one is the word mark. Word mark are registered as plain word, and this gives the highest degree of protection. Whereas sometimes we file a device mark, which is basically a logo or mark which is filed with the artistic work. But one thing which you should keep always in mind that device mark shall not be a huge composite mark. कि क्लाइंट ने बोला कोका कोला भी डाल दो, ओपन हैप्पीनेस भी डाल दो, टैगलाइन भी डाल दो, ऊपर एक सिंबल भी डाल दो, 4-5 ट्रेडमार्क का खर्चा नहीं करना है, एक ट्रेडमार्क को कंपोजिट बड़ा सा बना दिया और अप्लाई कर दो. So basically it is very harmful for the client, because when we register composite mark, or it contains when various things like logo, name of the brand, tagline, it will create rights and mark as a whole, and client will not get the protection if someone uses part of the mark. So it is better to protect each component of the mark as separate trademark for the better protection. Usually we file device mark only when there is generic word or part of the trademark or some descriptive word, which if filed in word format, it will be difficult to get it registered. On that time only we file device mark. Similarly, certification mark is provided to organization. Those provide certifications to other person or other entities. Then there is well-known trademarks. Well-known trademarks are those which have large popularity and known between the large portion of public. But well-known must be declared by the court. Or now even we can file an application to declare our trademark as well-known before the trademark registry after the formation of new trademark rules 2017, which cost 1 lakh rupees the statutory fee. Now we will see some example of trademarks. Like you can see, words are like Bisleri, Pepsi. They are simply written words without any artistic work. They have the best protection. Then we can register as a device in artistic manner like Coca-Cola, Nike. Even the tagline phrases can be registered like open happiness, just do it. Even symbols can be trademarked like Nike swoosh and McDonald's golden arches. If you see these tires, these pattern of tires are also registered as trademark. This Kit Kat, 4-finger chocolate is also registered as a shape mark. Then this Toberland triangle shaped chocolate is also registered as a shape mark. Then there comes color marks. So you can see that this gradient purple color is registered by the Cadbury, and no one else can use this color for selling their chocolates. Similarly, the yellow and green color is protected by the John Deere, and this blue color is protected by the Tiffany and Company, and red color is protected by the Coca-Cola. These are few examples of certification marks like super brands, Agmark, FSSI, BIS, ISI, Halal, ISO. Then there are sounds mark like Nokia Tune. Usually start Nokia phone in 1994. This was the sound, which was the first we beep we listened. So it is also registered as a trademark. So different trademark applicants and registration procedure in India. Now we will discuss it in details. So first, to register brand, we need to select the brand. So when choosing a brand, it's important to know what to avoid. So stay away from common words that describe goods, designate quality or quantity, or could offend religious sentiment. To avoid objection under Section 9 of the Trademark Act. For example, avoid names like number one dosa for a food stall, 1 dozen for selling food products, or best atta and pure water for a water bottle. Even avoid generic names too, like Makhan Bhog for selling butter, it's a generic word. But Makhan Bhog for selling atta is not a generic word. So the marks which is correlating with the goods shall be completely avoided. Also, always advise your client to choose a name which is not similar to earlier registered trademark to avoid the objection under Section 11. Your first priority should be to select a unique invented name like Dabur. Did you know that Dabur has no meaning at all? It was invented by Dr. Burman, who combined Da from the doctor and Bur from the Burman to create Dabur. Basically, in that time, doctor was pronounced as Dr. Saab. So he postmortem the doctor and Burman and created Dabur. So invented name might sound strange at first, but they have the ability to create a strong recall value in the public's mind. For instance, Bisleri has no correlation with the water, and Apple doesn't indicate phones. Astral might have sounded odd for the pipes, but today these are the top brands. Now, some of your clients might ask, we have chosen the name and started the business, but why to register it now? Can't we register it after it becomes famous? Because we don't know it will work or not, we might have to change the name. Have you heard about the smiley icons? Yeah, icons in your phone which you use daily. It was firstly drawn by an artist in 1963 as per the information available on the public forum. This graphic designer Harvey Ball was paid $45 to create a motivating design for the State Mutual Fund Life Insurance Company. But later on, it was used, it was registered by a different company, a French journalist who started writing a column and used this smiley logo. Later on, his son registered whole set of emojis which we are using in our phones. Now, this company is selling this smiley logo licensing rights to every mobile manufacturer, every chatting solution provider, or every software service provider who want to use emojis. They have to pay the licensing fee to this company. And now this brand is valued around 500 million USD across the product lines. So without registration, you got $45. So now you can understand the power of the IP and its registration and why it is important. Ask your client to never doubt on their efforts. If they ignore registering it on time, someone else could steal it and enjoy their goodwill. If you want to cook the food, you can't say, first give me heat, then I will give you wood. You need to give wood first to get the heat. Similarly, you need to register and promote your brand first to succeed. You can't say, first let me succeed and then I will register and promote my brand. Your brand is your key to success, so respect it and secure it to become successful. And always insist your client to register IP at the first instance because IP is the backbone of any business. So as I said, we should avoid these kind of names which are racist, name of includes name of gods, laudatory words, generic word, descriptive word. I have given you some example. Fair and lovely is now glow and lovely. Why? Because public find it racist because it was using the word fair. So they have to change the brand name. Similarly, best bakers, best quality product. So best is the adjective word, bakers is a generic word, quality product, best quality product, generic word. This mark was refused, as you can see. Similarly, this was a word mark, best choice of our, includes geographical indication. This mark was filed in 2017 and it is still objected and it might get refused. Similarly, this is the best cup. It is also descriptive. But the thing is that it has been filed with artistic work. Here comes the role of device mark. So this mark was registered, but it mark doesn't have any exclusive right to use word best or cup separately. It can use this as a whole. So word mark gives you protection to protect your mark as completely, whereas device mark will give you protection as a whole. So choose the type of marks very prudently. Now, who can file trademark applications? Trademark applications, there can be various applicants for trademark filing. Now, here it is important to know about the each applicants as fees will be different for the each applicant. First, I will try to put things together in a very simple way so that you can understand the things easily. Are you aware of the fee for the trademark registration in India? Fee for trademark filing in India is rupees 5,000 for individual and sole proprietor and rupees 10,000 for other applicants. Yes, you must be wondering that government is giving 10% discount if the application is filed online. Because when you file online application, you actually doing a lot of work on the part of government employee. So they are giving you 10% discount. So the fee for online filing will be 4,500 for the individual and sole proprietor and 9,000 for other applicants. And that's not enough. Government is again giving you 50% discount to other applicants if they are micro and small enterprise or recognized as startup. So fee for these entities also reduces to 4,500. Rest all the applicants have to pay rupees 9,000 if filing online as 10,000 case of offline filing. So it can be filed by individual, sole proprietor, partnership firm, LLP, company, trust, association, non-governmental organization, and even government organization. So now we will try to understand the registration process in depth. We have selected the brand name. Now we need to search whether it is clearly available or not. So we have to decide first our product will fall in which class. There are total 45 classes which is accepted globally and published under the niche classification. From class 1 to 34 classes are for the products and 35 to 45 are for the services. So first we need to select the brand, then we need to select the classes. At the end of session, I will show you how to search the trademark and how to find out the classes in which your client's product will fall. So after getting these data, we will search the brand, and after we are convinced that this trademark can be filed as it is not similar to any earlier registered trademark and it is not in our avoidable trademark list, we can file the trademark application and go ahead. So for filing of application, we can file it online as well as offline. So there can be two modes of filing application. One applicant file directly in its own name and other and trademark attorney or trademark agent can file the trademark application on behalf of client. To file online application, now you need class 3 digital signature of your client, which is actually available with you. Now the thing is that ipindia.nic.in, this is the website where this website can be used to file a trademark application, patent application, geographical indication, and design. For copyright, we have to go through copyright.gov.in. By these two websites, most of the IP rights can be filed in India very easily and conveniently online. So after selection of mark, we will file the application and we will need some basic information from the client like basic details includes name of the applicant, upload the logo, then describe give the description of the image. If the mark is filed in different language other than Hindi or English, we need to give translation and transliteration. Then we need to select user claim. There can be two types of mark. One is proposed user, which client wants to use in future but register it in advance. That can be filed as proposed user mark. And the other one can be filed as a user claim where he was already using it or his forefathers were using it. Now he wants to register the brand. So the trademark registration can be filed at any time, even after the usage of the brand. Whereas few IPs like patent and designs, they have to be filed before using it or publishing or showing it to public. Otherwise, they are not eligible for filing. But trademark can be filed at any time and oldest the user, better the rights. So never try to exclude old user from your client's trademark application. If he is using for last 5 years, 10 years, 15 years, you have to put that user and you have to file application along with the user affidavit. And at the time of filing, now you have to file evidence of the use also, because you cannot simply say I'm using it from 2010. Only mere declaration is not enough. You have to provide evidence that you are using the brand from 2010. So after filing of the application, trademark registry will examine it whether it is registrable or not. So majorly there are two kind of objections are raised. One is section 9 and the other one is section 11. Section 11 is for similar trademark. If the phonetic similar or deceptive similar or exact similar trademark are already on the records, then there can be chance of refusal of your mark because of existing trademarks. Similarly, section 9 is absolute ground for refusal if you have used these kind of words, which is laudatory, adjective, descriptive, which indicates the quantity of a product, then it can be refused under section 9. So when the examination report is issued and our trademark is objected under section 9 or 11, we need to submit a detailed reply why our trademark is eligible for the protection and how section 9 and 11 objection are not sustainable with respect to our brand. So suppose you have adopted some generic words in your brand like kurkure. Kurkure means crispy. So it was a not a invented name, but they have proved that they are using it for so long and they have created a non-distinctiveness. And now they have irritated non-distinctiveness and their trademark now can be identified by the any public. That's why their trademark was provided registration because of old use, promotion, and since the trademark was easily identified by its device mark, by its artistic work and packaging. So we can file reply according to our need and objections. And after filing reply, our trademark can be accepted. Great if it is accepted, but still if it is not accepted, then we need to file. Then we will be allotted a hearing date. We have to appear before the hearing officer, and we need to convince him that why this trademark shall be registered in our client's name. Once the trademark is accepted, it will go to go for publication in trademark journal. If it is refused, you can file a review or appeal in the High Court. Previously, appeal was going in the IPAB, Intellectual Property Appellate Board, but since now it is repealed, all the appeal will go to High Court, respective High Courts of the Trademark Registry. So after publication in the Trademark Journal, there is waiting period for 4 months. Then any person from the public can file opposition if he thinks that published trademark is infringing its right. Then opposition can be filed, then we have to go through the opposition module. If there is no opposition filed, then our trademark will get registered after the expiry of waiting period. And if the opposition is filed, then we need to contest the opposition to get our trademark registered. And opposition proceeding will include majorly two steps, pleading and hearings. In the pleading, first we will receive a TMO, notice of opposition. Then applicant need to file counter statement stating his grounds why its trademark shall be accepted. After providing the filing the counter statement, opponent is liable to file evidence within 60 days from the date of receipt of counter statement using evidence on affidavit under Rule 45 to establish why the applicant's trademark shall be refused and how it is infringing their trademark. Similarly, applicant has to file their evidence on Rule 46 under Rule 46, showing why their application shall be registered, providing their evidences. And after that, rebuttal can be filed by the opponent, and After this, pleading stage will be completed and hearing shall be scheduled by the trademark registry and decision will be granted as per the facts and legality of the case. So this is the trademark registration process which is concluded now. Now, what does it mean to have brand equity? We will explore now the fascinating concept of brand equity and its undeniable mark of distinction. Brand equity is more than just a recognizable name or logo. It's about being the first choice among a sea of alternatives. When consumer have a need, the brand that immediately comes to mind is the one strong brand equity. देखते ही जो क्लिक होता है उसकी brand equity highest होती है. And this preference is not by chance. It's the result of deliberate and strategic branding efforts. An integral part of this is called recall value. Recall value is the ability of a brand to be remembered by consumers, particularly at the point of purchase. It's about creating memorable experience and association that consumer can link back to your brand. However, the ultimate testament to brand equity is when your brand becomes synonym with the products or services you are providing. Consider how Google has become synonyms with online search or Xerox with photocopying. This level of brand equity means that your brand is not just a choice, but the default option for the consumer. And it's a testament to a brand's strength and it influences the market in conclusion. Now, what we can do, we can apply this principle on the branding strategy of your client and on its business so that you can do value addition in your client's need. Value addition means increasing your brand value. That means more professional view. It's your brand value that will make difference in your life, and it's all about the mindset. Like if you can see this end seal, I'm sure many of you will not be even aware what this product is, but whenever any consumer go to a shop, it will ask एक M seal देना. तो पानी टपक रहा है तो M seal चाहिए. But the name of the product is epoxy compound. You can see this machine. Most of the people call it JCB. It's not the product name, it's just a brand name. But nowadays it has become name of the product. This is earth moving machine. Similarly, there are a number of such examples like Xerox, Colgate, Bata. If you see this, what first thing comes in your mind is हाथ में चोट लग गई है तो सबसे पहले दिमाग में क्या आता है? सर्दी में होठ फट गए तो पहले दिमाग में क्या आता है? प्यास लगी है तो पहले क्या आता है? अगर आपको कट लग गया है तो सबसे पहले डेटोल याद आएगा. प्यास लगी है तो सबसे पहले बिस्लेरी याद आएगी. होठ फट गए हैं तो सबसे पहले वैसलीन याद आएगा. नूडल्स खानी है तो मैगी याद आएगा. लोग तो ये भी भूल गए हैं कि मैगी नूडल्स है. नूडल्स और मैगी बोथ आर सिनोनिम ऑफ द सेम थिंग राइट नाउ. इवेंचुअली ठंडा मतलब कोका कोला. इंश्योरेंस बोले तो LIC. These products have gained so much recall value and brand preference that they kill their competition. LIC was initially formed as Life Insurance Corporation, but it used its brand as LIC to avoid generic formation of their name so that they can protect their brand IP. So how did they do this? To create the brand preference, you should be clearly decide your goal, that how do you want to people look at your brand, and you need to maintain consistency and similarity in the brand image. You first need to determine the target audience and shall prepare everything accordingly, even it is for your client and for yourself also. When you maintain it for the long term, people make perception or image of that consistency. Like if you maintain the good quality or good services for long term, people will associate your brand with good quality and good services. मीन्स पीपल विल से इन सीए के पास में, इस सीए के पास में काम बहुत अच्छा होगा, पैसा चाहे कम लगेगा ज्यादा, because you have created that brand value with consistency by providing value addition to your clients. In same way, if you maintain same, like in hotel industry, firstly Oyo made perception that Oyo, if we book Oyo, we will get affordable charges, free Wi-Fi, clean linen, and free breakfast. Same was the case with the Ginger Hotel chain, which is by Tata for the middle class client segment. So they are clear that we want to target which audience and how, and they will maintain their consistency. They will advertise or make it viral on the social media, increase trustworthiness, and they will try to enhance their preferential index over the other competitors. So they are clear on what should you be known for. Like thumbs up always puts tufani karte hain, taste the thunder, and Coca-Cola is always for the family drink, open happiness. Similarly, the Pepsi is for the joy, and Mountain Dew डर के आगे जीत है. Like Vivo is clear, it is for the camera and music. It doesn't look for the other things, only camera and music. Like Oppo capture the real you. OnePlus never settle. You will be surprised that all the three brands belongs from the same company. They are the child of the same parent, but they have their different target audience, different strategy, and different brand recall value. Like if you see this, when you have huge brand recall value, people will recognize you with a single glimpse. As we saw, raised hand, immediately Congress will come to our mind, and then Rahul Gandhi. And upon seeing the lotus picture of BJP will comes in our mind quickly, and along with Narendra Modi. This is a reflex action जो देखते ही क्लिक हो जाता है. Now we have registered trademark, we have applied, we have guided our client to how to monetize the trademark by enhancing its brand value. Now to enhance the brand value, we need to license it, because if our client need to scale up their business, it can be achieved only through licensing. So we can provide right to use to any person. Even it can be given product specifically. Suppose our client is manufacturing 10 products, it can provide right for 2 products to a different company, right for 2 products to again different company in different place, different geography area. So where is our trademark valuations? So a trademark valuation is the process of determining the value of a trademark. A trademark valuation considers factors such as brand recognition, market share, future earning potential. Trademark valuations are the important for business transactions such as merger, acquisition, legal disputes such as infringement cases, even in the at the time of licensing and assignment. Now we will cover the infringement of trademarks in India. So basically, when a trademark is registered, our clients have exclusive right to use that trademark, and not even the same trademark. Even our client have exclusive right to use the phonetics, exclude the phonetic similar trademarks from copying. As you can see, James is the trademark of Cadbury, and this is a James Bond. So basically, structure of the mark is different, but they are phonetically same. So Delhi High Court imposed a cost of rupees over rupees 15 lakh on this nearest food products for violating the rights of the manufacturers of Cadbury Gems. There is an important doctrine of fading memory. The consumer does not have two marks or packaging available with him for side-by-side comparison. He only banks upon his memory. The memory retains only broad features of the mark and not the fine details. Thus, the overall visual and phonetic similarity has to be seen to protect the brand. As you are seeing, Colgate and Anchor in this slide, this is also infringement, but it can be protected through copyright as well, because the copyright will play a vital role over here, because the copyright is for the protection of artistic work, and the artistic work is color combination is totally copied by the anchor. Colgate was also using white and red background. Anchor also used the same white and red background and used the similar type of packaging. So the Delhi High Court held that law relating to trade dress was very clear, that a trader's goods are recognized by their general appearance or get-up. Accordingly, resemblance or get-up was commonly an ingredient in passing off. Then Court compared both the cans together and opined that Colgate and Anchor cans look very similar from a layman's perspective. The court held that a trade dress influences the overall impression that customer gets as to the source of origin of the goods. This is why this forms the visual impression of color combination, the shape of the container and packaging. So we have to protect all the things. Not only the trademarks, we have to protect our shape of the packaging also. Then we have to go for the copyright also. So one client can give us lots of work in terms of IP. So one person say, hey, Rastri is famous brand for pan masala. Can we use Rashi to gain some quick market share? The other one say, let's do it. But use of Rashi is banned by Delhi High Court and asked to pay 50,000 as punitive damages. Because Rastri and Rasi, where words was as deceptive and phonetically similar, and it was used to ride upon the goodwill of the Rastri. Delhi High Court here also restrained the manufacturer from using Rashi mark in respect of pan masala, mouth freshener, and other tobacco products, which were infringing the rights of Rastri pan masala. So basically, any confusing similar mark is also protected by the Trademark Act. So it is not like word to word. If we change one word, one letter, or one character, our brand will change. It is not like, even mark Nirala can be protected from the use of Tirala, because Ni and T can be written in a similar way, that it look similar. So mark shall also not be confusingly similar. Then there is concept of John Dewey order. It was very famous in the foreigns, and now it has made entry in the India also. So when new movie is releasing, or some apps are out, you will see that lot of people will copy it and distribute it, or even on the broadcasting channels. Local cable network will play the movie before release. These were the problems, and the problem was that how a copyright owner can go to each company and or to each infringer and protect the trademark or copyright. So there is a concept of John Dewey order. The picture Happy New Year, which was starring Saruk Khan and Jackie Straw, Abhishek Bachchan, they basically applied for this John Dewey order, and court given the protection of from any persons. Whoever use it, they can take directly action against that person because of this order. So it is a universal order for all the infringers. Similarly, criminal protection is also available for the infringement of trademarks and copyright. So first we need to collect evidence and prepare the complaint. Then we can move to police station for filing the complaint and convince police officer to take the action. Then FIR will be registered, there will be search, seizure, and there can be arrest. If sometime police officer is not convinced, or they are not filing our complaint or FIR, or they are obstructing, then we can go to court and file under 156(3) of CRPC FIR through the court. So we can file civil, we can have civil remedy as well as criminal remedy. In the criminal case, there could be 2 lakh of rupees of punitive damages and 3 years of imprisonment to the infringer. So, sir, now we can take Q&A for the trademark session.
Sir, we do have some questions.
Yeah.
Sir, the first question is from CA Nakul Arora. He
Yes.
says, I am working with on copyright case, which is
Hmm.
a case under Copyright Act read with IPC section 420.
Hmm.
However, our client was sold the products as a trader, where the party who sold the goods to my party is absconding. And
Hmm.
now the multinational brand is harassing a petty trader through litigation, etc. Is there a way out where a 65 years old person can get relief from imprisonment that I am missing in the law?
Okay, this is a very specific question, but I would like to tell you that whenever any person who is infringing trademarks or copyright of other person, they can be challenged because no printer is allowed to print the stationery of the registered persons of others persons because they have to take the evidence that you own this brand before even printing. Similarly, a trader who is buying a goods from a person, they can claim the protection that we were buying it, seeing it as it is legitimate transaction. We are buying it in the invoice through the invoice, and we were supposed that we are buying the goods from the original manufacturer. That defense can be taken in the court, but it shall be uh, produced with the evidence that they were bona fide. If they were bona fide, the court will give the relief to the that person. But if there is no invoice and that can't be proved, then there is no way they have to fight it out in the courts.
Okay, sir. So, another question is from CA Nakul Arora, sir, only. He asked, can we register as a trademark agent as a CA?
So this is a very specific question. If you will read the rule, in the eligibility, there is written like graduate, any graduate can apply it. Company secretary, advocate is by default a trademark attorney. The company at CS and advocates need not to be filed as a give exam for the trademark agent. Chartered accountants can give exam and become a trademark agent as in the disqualification an insolvent chartered accountant is disqualified when someone is disqualified from being a trademark agent or for the when someone is mentioned in the disqualification, that means he is qualified to be a trademark agent because almost everybody is graduate in the chartered accountants fraternity. Also, every chartered accountant is graduate, so they can file it. But the thing is, what your institute is saying, if they are allowing you to do this side by side, it's fine. But if they say that you have to you have to take NOC from the and drop your COP from the ICI, then you have to check it out. Otherwise, you can file trademark application directly as representing directly as in the capacity of the client, or you can associate with any trademark advocate or CS, and you can work in this field by the association and collaboration, so that you can avoid the issue of controversy also, and you can very well use this opportunity for your career.
Okay, sir. Sir, Vijaya Singh asks, can anyone file or only lawyers and company secretaries? As CA, why cannot we get licensed to practice too directly without exams?
Yeah, exams they have to given, but firstly they need to clarify with the ICAI, because as per my limited knowledge, ICAI has not clarified that they will allow chartered accountants to be registered as trademark agent or not. Otherwise, you have to give the examination. You cannot directly work as a trademark agent. You have to give the exam.
So next question is from Aman Mohan Jindal. His question is that if no invoice is there, how the act is breached?
If no invoice is there, how the act is breached? Okay. When you are doing any illegal activity, then when your place is searched, you have red-handed, caught red-handed, with the products, infringing products, it is already established for the plaintiff that you are infringing their trademark. Now it is your duty, or you are bound to prove that how you were not infringing. So invoice doesn't matter if you have it or not. If you are possessing any products which is infringing copy of the others trademarks or copyright or any IP, you are accountable.
Okay, sir. That's it now, sir.
Yeah, thank you. Then shall we continue the session?
Yes, sir.
Yeah. So now we will have a brief look on the design registration. So what is actually a design is? A design is a aesthetic aspects or outward appearance applied to a product. It can be 2D, 3D, or combination of both. So anything which we can judge by our eye that is different and unique, like if you see this glass, I don't know it is visible or not. I think it is not visible. So yeah, just a second. Yes, you see a Fanta bottle. It is twisted from the bottom, and this is not a normal bottle shape. It is created by the company. Why? Because it can distinct any other bottles from other bottles. So if even this sticker is not here, we can identify this that this bottle belongs to Fanta. Why? Because of its unique shape. So there shall be novelty aspect and unique design basically attracts the attention of people, and people tend to recognize the product primarily through its form, shape, or structure. Hence, design means features of shapes, pattern, configuration, ornament, or composition of colors or lines, which is applied in 3 dimensional or 2 dimensional or both in the forms of using any of the process, whether manual, chemical, mechanical, separate, or combined, which is a finished article appealed to or judged wholly by the eye. The thing is that it cannot include the mechanical features of any product. Mechanical features will be protected by the patent, only outer appearance will be protected by the design. So design shall be novel, no prior publication of design. Any design, if it is published prior to your filing of application, then you cannot register it, or if you have already registered it, it can be cancelled. So advise your client, if they want to apply for the design, they have to apply before publishing it or getting it out from their hand. Design should not be contrary to public order or morality or security of India. Also, application of design shall be applied to an article through industrial process. Now, there are many valid reasons under the Design Act to protect this. First of all, industrial design protection favors fair competition in the industry by encouraging creativity, originality, novelty. The design of a particular product increases its marketability as well as commercial value. When a design is registered, it becomes exclusive to the owners, and the consumers can easily identify that the products belong to a particular brand. Registered design can be sold in the market or can be used for paying liabilities and becomes a business asset. So why to register? Why to register? Statutory rights only occurs after the registration or by filing the application. So it given right to prevent others from producing, importing, selling, or distributing products having an identical appearance. Gives your client a USP, unique selling point, because no one can copy this design. It is an asset and can be licensed or sold. So for registration of design, we need to file an application with the specimen copies of the design. A statement of novelty should also need to be submitted along with the photographs with photographs showing from each angle. The design shall be shown from the each angle front, right, bottom, top. And the fee for design filing is the official fee for design is registration is 1,000 for an individual or natural person. For small entity, it is 2,000, and for applicants other than small entity, it is 4,000. Renewal of design cost rupees 2,000 as of now. Once registered, the design is valid for the 10 years, and it can be further renewed for 5 years. So trademark can be renewed for the infinite time, whereas design can be protected only for the 15 years. That's why some of the prominent companies, they protect their shape as trademark because the trademark protection is for the long term. So now we will deep dive into many CAs are involved in the insolvency professional these days. So in insolvency proceeding, IP rights can be a valuable asset that can be monetized to pay off the creditors. So the IP assets are evaluated based on their uniqueness, protectability, and commercial viability, and insurance professional is duty bound to properly value the IP rights and properly execute them by licensing or selling it so that they can recover a large amount of fund from the IP and the creditors can be paid. Recently, in one case handled by us, we came to know that one promoter, transferred all trademarks in his personal capacity from the company at a very nominal price, very nominal value, which was definitely undervalued and fraudulent transfer as per section 43 and 66 of IBC. So we filed complaint and it was reversed by the NCLT. Even few companies which are asset light are heavily dependent on the IP rights. For example, Ola and Uber, biggest cab service without owning a single car. But what they actually own, IPs in brand, software, customer database. Similarly, Ericsson's produces no mobile, but biggest provider of technology to mobile companies like Sony, Samsung, Apple. Each products manufactured, which is using telephone technology, using SIM card, they have to pay the license fee to Ericsson. Similarly, biggest hotel brand without owning a single hotel is Oyo. So they all are asset light model and their IPs are valued in a much higher way. So when you are playing a role of insolvency professional, you have to check the brand value, the transaction even executed 2 or 3 years back. Because this transaction was also executed 1.5 years back from the filing of insolvency because it promoter was already knowing that they will fall into this trap. They will have to go through the insolvency proceeding. So they, prior to filing of the insolvency proceeding, they took the trademarks out in the undervalued condition. So now copyright. So basically copyright protects the original works of authorship, such as books, music, videos, and softwares. It gives the creator the exclusive right to reproduce, distribute, and display the work. Copyright protection is actually granted for the lifetime of the author. And this is not at all. Even after his death, his legal heirs can enjoy the protection of copyrights for the next 60 years. So for a company, or entity, it is protected for the 60 year only, but for the natural person, it is protectable for the life and plus 60 years. Copyright registration is not mandatory and protects our work automatically as soon as it is created. But then why do we need to register it? We have to register it to create evidence for the protection of our work like books, articles, sound, music, movies, lyrics, artistic work, packaging, design, and trade dress of the products. Because when we created the work, it is automatically copyrighted. But without registering it, we will not have the evidence that we have created it at the first instance. So registration is the first evidence of your creation. So it is better to always file a copyright application. Many of you guys are writing books, so I will suggest that you should take copyright on your books or articles on your own also, so that no one else can use it. When you write a book, your when you attain rights on your books, your rights are not only limited to printing books, but adoptions in other formats like movies, audiobooks are also protected, and you can monetize the same. Like Chetan Bhagat has brilliantly monetized his books into the movies. Once you have authorship of any copyright, moral rights will always remain with the author even after the assignment. Likewise, in the first time, Chetan Bhagat was not happy with the credit title given to him by movie Three Idiots, and they had disputes over the title, credit for the title. Later on, it was resolved with the producer, and even in India, softwares are also protected by the way of copyright. But if you have copyright and hardware, a combination of software and hardware, then it can be patented. Then it can be protected by the filing of patent. But if your client is having simply coding of any programming app, then their software will be registered through the copyright in India, and it will fall in the literary work. So there are a few types of copyrights which we have discussed. Sound mark, in the form of literary work. Literary work includes books, writings, and softwares. Because softwares are also written coding, so they are also protected under the literary work. So if your client is using it for the protection of artistic work, then they first have to file for NOC from the trademark registry. They will file an application in the form of TMC for getting the NOC from the trademark registry that we want to register this artistic work for a product. And after obtaining that NOC, we can file Form XIV with the copyright registrar by filing all the basic details, and we can get our copyright registered. So this is also very simple process and online process. It can be done easily by anyone. Chetan Bhagat has written so many books and converted it into so many movies, like Two States, Half Girlfriend. This was a case which was filed in 1989. This case actually involved unauthorized remake of the classic Indian movie Ram Teri Ganga Mehndi. This movie was basically copied by a Tamil producer, and they launched Tamil version of film called Puddu Puddu Arthangal. So the Bombay High Court ruled in favor of RK Production and prevented the release of the Tamil film, and setting a precedent for future copyright infringement cases in India. So since the movie was not even released, they suffered a huge loss monetary in terms of monetary loss. So it is always better to protect, register our copyright so that we can get protection from them. Similarly, Anil Kapoor Production has sued T Series for using the song Mere Bina Tu from the film Fata Poster Nikla Hero, alleging that it was a copied version of song Dil Mera Mukt Ka from Agent Vinod. So eventually the case was settled out of court, and T Series agreed to pay a sum of rupees 50 lakh as compensation for using a single sound music. Recently, Mr. Mukul Rohtgi brought the two bottles of whiskey, Imperial Blue and London Pride. Everyone in the court was mouth watering that what we will do with these bottles after the case is argued. So basically, in this matter, you can see the formation of the label in London Pride and in Imperial Blue are of the similar nature, and even in the Blender's Pride. In Blender's Pride, they have changed the color combination, but overall impression of this shape of this here curve and this curve, all three are same. Then they have used similar kind of this device here and here. Imperial Blue and London Pride both are same in the background also. So code directed London Pride whiskey maker to consider changing the packaging. So here trademark is perfect. Imperial Blue have no similarity with even in with Blender's Pride or London Pride. But packaging that is protected by trade dress as well as copyright, it was asked to stop using this similar packaging because Imperial Blue has copyright over this label. So this is another thing where you can use intellectual property rights for structuring of the company. In this company, you can form three different entities. One is a parent, the other one is IPR holding company, second company is looking for the operations, and third company is looking for the investment. Suppose your clients who are aged, they can rest in this IPR holding company and investment company because they don't need to look into the daily operations of the company. They can enjoy their royalty and interest by having stake in the this IPR and investment company. Then there is operating company. When there is a huge family, there are various first generation, second generation, third generation. Suppose from third generation, one person want to do a business, second want to do a B business, so they can take investment from the investment company, give them interest, pay the interest, and they can even make a JV with other person. IPR they will get from the IP holding company. So basically, this operating company will have only operating profits. So if this JV, which can be partnered with the other persons also, will not have the rights of IP, so IP is protected, which is created by a huge efforts, like JSW. Previously, it has asked for 10% royalty from its subsidiary, which is listed company. Shareholders denied. Then later on, it was agreed in a lesser term, but now they are getting the royalty because of their IP holding company. Previously, it was also used as a tax saving tool because there were many tax haven countries where companies register their IP holding and a company, and all the IPs of the company was transferred to that company in that particular country. So in India, suppose they were making 100 crore profit, they will give 90 crore in the name of royalty to the IP holding company, and 10 crores will be adjusted with the expenses, and very minimal profits were left for the taxation in India. And in the foreign company like Liechtenstein, Switzerland, Cayman Island, they were basically providing 80% exemption to the IP income. So out of that amount, 80% was exempt, the rest 20% was charged at 30%. So ultimately they were paying only 6% tax. So this was also used as a tax planning tool also. So as we discussed, taxation planning plays critical role in leveraging IPRs for the financial benefits, and government offers several tax incentives such as patent boxes to promote innovation growth. Transfer pricing helps companies optimize tax benefits by negotiating fair prices for cross-border license agreement. By leveraging these incentives, companies can reduce their tax liability and maximize their profit. So basically, you can help your client to plan taxation through the IP rights. Then comes the Patent Act. So basically, patent is a type of intellectual property that plays a very vital role in monetization because this is attained by a thorough research and it is developed by a lot of efforts. So once one invention is made, it has a lot of potential to be monetized over all across the world. But let me clear you, whatever IP rights we have discussed, if we register it, they are all protectable in India only. Only the copyright is universal. Otherwise, all the IPs are registered locally only in the India. And if you want to register in the different companies, we can file the same through the help of WIPO. Through WIPO, we can file a Madrid application for trademark registration, design also, and patent also. So we can select various companies as per our need, pay a single fee to the WIPO, and WIPO will take care of all the details and forward our applications to different companies, and it will be processed. If any objections are raised, then we need to reply to each country separately through WIPO only. So basically, WIPO will be the one point of contact for all the needs. So similarly, patent is for the new innovation, and a patent is a type of intellectual property that gives its owner the legal right to exclude other from making, using, or selling an invention for a limited period of time in exchange of for publishing and enabling disclosure of the invention. So once patent is registered, it is valid for 20 years. After that, everyone can use the patented technology because it is now it can be used by the public at large. So why patent registration is very important? It ensures complete protection against the infringement. Patented invention is tradable, generates substantial income and return on investment because huge investment is done for the patent. It improves the market presence, permits public disclosures, and trigger innovations. So basically, patent is the company, the country which highly participate in the invention has is to get soon in the list of developed countries. So these days, government is also encouraging Indian startups to scale up the R&D and invent new products so that India can also have technology leverage at par with the countries like Japan, US, Israel, because they are highly engaged in the developing new technology. And India is also now in the same lines. There are numbers of patents filed each month nowadays, which was not actually previously was filed in the year. Now it is filed in a month. So who is eligible for the patent registration? First inventor who has invented the product or the process is eligible for the patent registration, or assignee of the true and first inventor. Suppose there is a company who has hired a scientist, he is doing R&D, he has developed a product, but he is under the hire purchase and hire agreement. So all his research work is already assigned to the company. So the company will be assignee of the inventor and company can file for the patent. Or representative of decreased investor can also file for the patent in India. So what can be patented in India? Any products which is new and inventive physical item. Process and methods can also be protected in India. Like you will be surprised that even Jaljeera was patented in India previously. Now it is gone. New and useful machines or mechanical invention, manufactured articles, chemical compounds, biotechnological invention, software which is having implemented hardware combination can be protected under the patent. Only if there is only software, then it will be protected under the copyright. So official fee for filing a patent application in India for a natural person is 1,600, and this is the fee for the 30 pages, 10 claims and single priority. Extra fee will be payable for each additional priority, extra claim or extra pages. And for large entities, the official filing fee is 5 times higher, that is 8,000. And for startup, again, there is discount of 50%. So basically, we need to draft first we need to check the availability of the patent, whether this patent is already not applied or registered, we need to check the invention criteria. Then we need to draft a patent application. Then we need to file the patent application with the patent registry. Then we will apply for the publication. Patent will be published. Then we will apply for the examination. After the examination, if the registrar is satisfied, he will publish the application and grant the patent. And if he is not satisfied, we need to attend the hearing and satisfy the registrar. So basically, can a chartered accountant directly file the patent? Answer is no, because even advocate can't file the patent directly. Advocate also has to be a patent agent to file the patent, and you can file the patent with the help of any patent agent in collaboration to help your clients to grow their business, because patent is also backbone of the any business. Then there is geographical indication. What is geographical indication? A geographical indication is a sign used on products that have a specific geographical origin and possess qualities or a reputation that are due to that origin. In order to function as a GI, a sign must identify a product as originating in a given place. The qualities, characteristics, or reputation of the product should be essentially due to this place of origin. Like Bikalini Bhujia. The unique taste of a bhujia can be attributed to the specific environmental and geographical condition of Bikaner region. That's why that distinct flavor is developed and enhanced by the condition cannot be replicated if the product is made elsewhere. So only manufacturers who are manufacturing in the region of Bikaner can use word Bikaneri bhujia on their products to sell the namkeen. And even those manufacturer has to be members of that association who has filed GI for the registration. So basically, manufacturers association is filing the application for a particular GI, that this particular thing, like Darjeeling tea, it was the India's first product to get GI tag. Like basmati rice, known for the distinct aroma and long slender grains. Kanchipuram silks, known for its quality. And these are the few tags which are recently provided in India. It is Kandamal Haldi, which is from the state of Odisha. Then Odisha Rasgulla, again from Odisha. Kodai Kanal Malai Pundu, it is from Tamil Nadu. Poundam from Mizoram. Then there are various products from the various states which are recognized as a GI indication recently. GI application can be filed by association or manufacturer of association of manufacturer of a particular region by paying fee of rupees 5,000 with the statement of claims and evidence that how that geographical condition is giving an extra age or characteristics or enhancing the product value due to their geographical condition. And upon receipt of the same, registrar will decide whether it is registrable under GI Act or not. So I will try to connect the dots in these slides to IP related stuff only, as on this subject you all are expert. So Caro. This Caro order was previously only related to the fixed assets, but now from the 2020 onward, intellectual property rights such as patents, trademarks, and copyrights have gained immense prominence. These intangible assets carry significant value for a company and it cannot be ignored. So the company order is an order issued by the government of India to enhance the overall quality reporting by the company auditors, and auditors are duty bound to now check under Coro to report whether the company has revalued its property, plant, equipment, it was previously, or intangible assets during the year end. This means that if a company has significant intellectual property rights, these would need these would need to be audited under CARO to ensure that their value is accurately represented in the company's financial statements. For a detailed understanding, you may refer to the guidance note on the company's order 2020. Because there is huge impairment loss for the companies like pharma. Intangible assets are required to be valued year end at in the pharma companies due to impairment loss. It's huge and competition is severely globally. For the instance, you can see the reports of Dr. Reddy, which made an impairment loss of around 380 crores. These are all technical words, so please ignore my spelling. So Nuvaring equivalent product has impairment loss of rupees 318 crores. Similarly, there are other products, Sexagliptin, metformin, and phentermine and topiramate. They incurred loss of 158.7 crores. Similarly, their other assets incurred 115.9 crore of loss, impairment loss. There is physical asset only incurred 4.6 crore loss. If you will see this, the report of this company, I think, as per my limited knowledge, 6 to 7,000 is the physical property, and 25 above 25,000 is it is the IP which the company is having. So basically, when you are trying to value a company, you have to check that how it can be valued at the time of assignment or legal due diligence, so that any chartered accountant can enhance a value addition to their clients' IP rights. Recently, I would like to share a personal experience. One of our client who has just started a brand for the clothing segment, and within 1 year, he was just arose between a turnover of 50 lakh to 1 crore. But one big company was very much interested to acquire that brand. And that company contacted the client and asked that we want to buy your brand. So client called and discussed, sir, whether how much amount I shall tell, because I have spent around 25 to 50,000 on my brand. So I can ask for 5 lakh. Will it be a very huge amount? Then I told, don't disclose any amount from your side. First ask your client. First ask your buyer to provide his valuation. What value he is ready to provide you. So that buyer directly made an offer for 5 crores. So he was asking for 5 lakh and the offer was made for 5 crore. Then the deal was closed at 9 crore. But was it a fair deal? Was the valuation was fair? If that buyer's chartered accountants or team had made any due diligence, they would not have made this kind of offer, because that client brand was not having that valuation. It was very largely huge overvalue. But since the valuation parameters was not taken care of, the deal went on and client got the 9 crore. So that's a good thing for the client, but for that buyer, it was not a good thing. So valuation is very important, and who can be a better person to decide a value than a chartered accountant? So this we will end the we will go for the question and answer now.
Sir, we have some questions.
Yeah.
Sir, Mr. Mukesh Pandey asked that our firm name is the Tax Partners. Our competitor's name is Tax Partners, which is registered under trademark. Can we apply the same trademark If not, then what is the way out?
Okay. Now, as I told, I will go for the search and the classification part, which is skipped. So I will share my screen. We will take participants to the search part, and we will try to figure out the answer to that questions. The first thing, the trademark name is the tax partners.
Right.
Right. And the registered name is tax partners.
Sir, the competitor's name is registered under trademark, which is tax partners.
Okay.
And Mukesh Pandey, sir, says that his firm's name is the tax partners.
I hope my screen is visible now.
Yes, sir.
So basically, this is a public platform available for everybody. They can search the trademark from this site. We can access it through ipindia.nic.in. This is the page of the IP India NIC website. You can go in trademarks, link, and click on the public search. So it will open like this. So there are three options. Start with, contents, and match with. First, we will start with the partner. They have registered as partner tax. They can be. They might have registered in class 35, or I have a counter question to the Mr. Sorry, I just forgot the name. Who is the prior user? The partner tax or partner tax?
Sir, the registered name is tax partners.
Tax partners. Who is the prior user? Tax partners or the tax partners?
Just a second. Actually, sir, as far as I can read, sir says that the tax partner were already registered.
So we can see.
And they want to apply for the tax partners.
So this is tax partner. It is applied as a device mark, but this device doesn't contain any artistic work. It is simply written as a tax partner, but merely an image is pasted and there is some difference in the font, but they are not very aesthetic. So we can say that this tax is a generic word for the accounting and taxation consultancy services. Partner is again a generic word. So tax and partners cannot have exclusive right. So device mark has to be filed in this case. They have filed device mark, but this device doesn't contain any a very good logo like we seen in the best cup. So there might be chance of refusal in this trademark. It is pending from the 2012. It is not registered right now. It is objected because the name is generic. There can be problem. So it is better to avoid the generic words. Bookmyshow.com is a very big brand, and everybody I think know it. But the thing is that they adopted a generic name, and nobody was there to guide them on that time. Now the brand is very big. They have large reputation. So people tried to copy it, and someone started using it like bookmysports.com. They approached the High Court for the injunction, but the injunction was denied because court ruled that Book might show is a generic word and it cannot be distinctive of any product or service. So this trademark is not protectable. So it is better to avoid the name which are generic. So in this case, the tax partner can apply, but it is highly litigative word. They are already using it. There are chance of litigation since it is not registered for everyone.
Sir, Mukesh Pandey sir says that please check under class 45.
Yeah, we will check under that class also. Now this tax partner is registered. Why? Because this have some artistic work which is not common. Now there is high risk for with this Narayan Kumar Rai because they have filed this trademark is proposed to be used, whereas this logo is used by Ms. Jyoti Arora from 2017. So there is high chance of refusal for this mark. But as I said, try to avoid generic words and use invented trademarks. So for the search, we need to type the mark here. We will type Flipkart. We will search for the class 35, which is for the retail and e-commerce. You can see the report now. This is a word mark which was applied in 2009 with the user claim of 15th of October 2009. Now it is under the rectification. Rectification means somebody has filed cancellation of this trademark because they consider that this trademark is infringing their rights. So once a trademark is registered, it can be subject to cancellation under the Trademark Act. Anybody who is feeling a grievous person can file the rectification proceeding for cancellation of a trademark. So you can see this is a word mark, then device mark with different colors. Then they have filed various trademarks. Advantage, Flipkart First, in various languages, protected in any language. Like घर बैठे घर सजाओ. If they have filed only this single trademark, their protection were limited to that this mark shall be used as a whole. By this trademark, they cannot get protection for the word Flipkart. So they applied Flipkart separately and applied this separately. So whenever your client comes to you, you have to guide him that you need to file separate trademarks for the separate parts. If your client is tight on the budget, ask him to wait and file few months later. They can file one by one, one by one, but they have to file like this way so that they can get protection. Because if we try to file single application for all the composite marks, there is no protection available to client. So that single registration is of no use because they will give very limited rights. So any other question? Yeah, for classification, we can click this. We can click on this class details. It will take us to this. And here we can search any product. if you would like to ask anything.
Yes. So next question we have is, can an individual apply for copyright, and what is the fees and where it can be applied?
Yeah, copyright can be applied through online portal copyright.gov.in, and the fee will vary on the types of copyright. If they are filing for the literary work, it is 500. For artistic work, it is 2000. For sound work, it is 500. For drawing, it is 500. So it is depending on the types of the copyright they are trying to apply. But they can apply on the form XIV on copyright.gov.in website, and all the procedure is online. Even the hearing will be scheduled online. Any individual can file the copyright application. But before filing copyright application for the product, they have to obtain NOC from the trademark registry by filing form TMC. That is applicable only for the artistic work which will be used on the goods or service.
Sir, the last question is, basically it's just a general guidance from your side which is being asked. Sir, please share some details about the exam, when we can take it, how to apply for it.
Okay. Sir, you will be notified at this place when the exam will be scheduled for the agent, and it can be applied. This is the training and courses. You can join in any course. You can join in training course also. You can join online course also, and you can even join for the offline course also at NIPM at Nagpur. It is headquartered at Nagpur, and these exams actually are launched on gap of few months. So you can find the information from this site only, like patent agent. You can use this website to get all the information related to even filing of your form and everything.
Sir, that's all for the questions for today.
Yeah.
So it's my privilege to propose a vote of thanks for this webinar. My heart fills with a lot of gratitude and respect for our guest speaker for not only sparing his invaluable time to grace this webinar, but also enlightening us with his commendable talk on the topic. I express my thanks to our chairman and vice chairman also for organizing such knowledge enhancing webinar. Last but not the least, I give my heartfelt appreciation to all those who contributed and participated for making this webinar a success by joining it. Thank you so much, sir.
Thank you very much for inviting me, and thank you very much to all the participants for hearing and hearing me. Thank you.